In today's video, we're going to discuss the 5 different ways that you can establish service connection for your disabilities. My name is Attorney Greg Rada. I'm an Air Force veteran, and I've been representing my fellow veterans against the VA for the past decade.
My name is Victoria, and like Greg said, our video today is explaining service connection and 5 ways to establish it. So we're going to go over direct service connection, VA presumptions, secondary, aggravation, and then finally 1151s. So Greg, before we dive into those, I want you to give a brief description of what service connection means.
Well, service connection is the first step to receiving disability compensation from the VA, and it means that you need to establish that your disability is related to or caused by military service.
There's generally 3 elements to service connection. Talk about each element.
Yeah, so to win service connection, you have to show 3 things. There has to be some type of in-service injury or event that caused the disability. Then you have to have a chronic disability, meaning that it's an ongoing issue. It can't be something that happened once and then resolved. You have to have a current chronic disability. And then the final step is that you need a medical nexus opinion stating that it's at least as likely as not that your current chronic disability is related to that in-service injury or event.
And with the nexus opinion, who provides that?
Well, generally, when you make a claim for disability compensation, VA is going to request a CMP examination, and they're going to ask the examiner to give an opinion as to whether they believe it's at least as likely as not that your disability is related to military service.
That actually brought up a commonly asked question when you said generally they will do a CMP exam. Is the VA required to do a CMP exam?
So VA has a duty to assist, and that means that they are required by law to help you prove your claim. And so they have a duty to assist you by obtaining you a CMP examination and medical opinion. However, it's not an absolute right that they have to get it for you. The threshold or the bar is low to trigger their duty to get it, but it's not complete. And so what that means is, for example, if you make a claim for something and you don't have a diagnosis or you don't have any medical evidence or a written statement describing your symptoms, and then there's no evidence of anything happening in the military, VA might just outright deny your claim without ever getting you an examination, because they're going to say, there's no evidence you have a disability. There's no evidence something happened in the military. So you have to provide them with something to trigger that duty to assist to get that medical opinion and the examination.
Okay, so with that little background, let's jump into the 5 different ways. So the first way, and probably the most obvious way, is direct service connection. So can you explain what that is?
Sure. So direct service connection means that the disability is directly related to your military service. You know, you fell in service and injured your back. There's medical records indicating that it's been a chronic problem since then. VA is going to find that your back disability is directly related to your military service.
Okay. And with direct service connection, do you need to have an official diagnosis?
Not always. This goes back to the duty to assist again. It's generally better to have a diagnosis of whatever disability you're claiming. Otherwise, VA may say there's no evidence you even have this disability. This comes up a lot in mental health claims, PTSD, depression, anxiety. You know, a lot of people don't like getting treatment, and so they don't have a diagnosis. I feel that VA is a little more lenient on mental health claims. They understand that a lot of veterans don't get mental health treatment. And so when we're helping a client with that, you know, if they don't have any treatment, they don't have a diagnosis, we like to do a written statement from the veteran describing their symptoms. So there's something for VA to say, okay, you know, the veteran's reporting these symptoms, we'll get them the CMP exam. And then hopefully at the CMP exam, veteran will end up with a diagnosis, whatever their mental health condition is.
So let's move on to VA presumptions. presumptions, the second way to establish service connection. And I want you to specifically address how presumptions are different than the other ways as far as the three elements of how you win service connection, how presumption changes those elements.
Yeah. So presumption or presumptive service connection simply means that if you have the diagnosis and you have the type of service required for that presumption, VA is going to automatically assume that that disability is related to service. And there's many types of presumptions, and we're not going to get into all of them today, but probably the ones that people are most familiar with are Agent Orange presumptions or Gulf War burn pit presumptions. And so the presumptive regulations eliminate the requirement that there must be a medical nexus opinion linking your disability to service. VA creates presumptions because they've done studies already, and they've determined that, yeah, these certain disabilities are caused by this type of service. And so if you are exposed to Agent Orange and you've had prostate cancer or diabetes or Parkinson's, you don't have to prove the connection. You just have to show you have the diagnosis. You have to show you're exposed to Agent Orange.
And in some circumstances, you don't have to even prove exposure, right? There will be a presumption of exposure if you were certain places during certain times.
Yeah. So Agent Orange and the burn pits, if you had service in Vietnam and some other places, you're presumed exposed to Agent Orange. You don't have to actually show that, I came into contact with Agent Orange. If you're in Vietnam, you're presumed to have been exposed. Likewise with burn pits, if you had service in Iraq or Saudi or Afghanistan, you're automatically considered to have been exposed to burn pits.
And we've addressed this in a previous video, but when a lot of people think of the PAC Act and call us, they're under the impression that the presumption is saying, if you were in this place, then you're entitled to this money. But really the presumption is saying, if you have this illness and you were in this place, you're entitled to this money. So if you are a healthy, able-bodied person, no ailments, you're not entitled to anything because of a VA presumption.
Yeah, you have to have a disability caused by that exposure. VA doesn't compensate you just for being exposed. You have to develop a disability.
All right, moving on to secondary conditions. So if you can talk about what that is and if the requirements are any different for that.
The secondary service connection is when a veteran has a disability that's already service connected and that disability is causing another disability. And so I've highlighted the regulation here for secondary service connection, and it says disability which is proximately due to or the result of a service-connected disability shall be service-connected. It's pretty straightforward. For example, if you have really severe flat feet and you don't have arches that can absorb the weight of you walking, that might then cause you to have a disability in your knees. And so you can establish service connection for your knees, even though it wasn't caused by military service, as secondary to your service-connected feet.
So in order to achieve a secondary service connection, there always must first be service-connected disability.
Correct. You have to have a service-connected disability that's now causing this new problem.
So you have your current disability, you have a service-connected disability, and then you prove the link between the two.
Exactly. And I encourage veterans to research this.
Mm-hmm.
One disability can cause so many other disabilities, like hypertension can cause chronic kidney disease. Hypertension can cause tinnitus. Some of these secondary conditions aren't immediately obvious that there could be secondary. And so, lots of times, you can go into ChatGPT or Google and just type in, what kinds of problems does hypertension cause? Or what kind of problems can a knee condition cause?
And then see if any of those are things you experience.
Exactly. One of the nuanced areas with secondary service connection is weight gain. Weight gain itself is not considered a disability subject to service connection, but you can use weight gain as an intermediate step between a service-connected disability and another disability caused by the weight gain. So I'm going to use the classic sleep apnea example. Let's say you're service-connected for depression or several physical conditions which result in you overeating, not being able to work out. And so you've gained weight now, and that weight gain has caused sleep apnea. You can't service connect the weight gain, but you can use that to say, I've gained weight because of my service-connected depression and physical conditions, and that in turn has now caused me to have sleep apnea, and you can win sleep apnea on a secondary basis that way, and that's called using weight gain as an intermediate step.
Is weight gain in and of itself ever service connectable?
No.
Okay.
It's just you can use it as a stepping stone to get problems caused by the weight gain service connected.
So if you had service connected disability and you were taking a medication for it, and the medication then had side effects that caused other things like weight gain, which led to depression or something like that, then the weight gain could be, again, a stepping stone to link the depression to.
Yeah, if you have a service-connected condition, I've had clients who take tons of painkillers, which in turn then causes GERD.
Mm-hmm.
You get GERD service-connected secondarily to your physical disabilities for which you were taking the painkillers.
Let's segue over to the fourth way, which is aggravation. You already have the definition up here, so explain that.
Aggravation is when you've already had this non-service connected disability, but then you have a service connected disability that's made that non-service connected disability worse. And the important thing to remember in aggravation is you have to show that this non-service connected disability got worse by the service connected disability beyond the natural progression of that non-service connected disability.
How do you generally show that? Through an opinion?
Yeah.
Okay.
It's going to be an examiner or doctor or medical professional basically saying, if the veteran didn't have this service-connected disability, this other one would not have been as worse.
Okay. So if you had a pre-existing condition that's noted on your entrance exam, and that were to get worse, does that still qualify?
Yeah, that's like an aggravation direct service connection, kind of a hybrid. And so you don't need a service-connected disability that's made it get worse. And we see this a lot with flat feet. Vets will come into their entrance exam and that will show that they have flat feet, but they're asymptomatic, meaning they don't have any symptoms. If they then have service treatment records over the following years while they're on active duty that show the flat feet had gotten worse from the boots, from the marches, from the runs, they can say, yes, I had flat feet before I came in. This wasn't directly caused by the military. However, my military service aggravated my flat feet beyond, their natural progression, which means beyond what they would have been if I hadn't gone into the military.
Let's talk about the final way to establish service connection, the 1151s.
So Section 1151 claims are claims where a veteran has suffered a disability due to medical treatment or vocational rehabilitation by the VA. It's essentially a personal injury type of case against the VA. And so you'll see this is in 38 USC 1151. So that's why people call them Section 1151 claims. Mm-hmm. You can read down here that you have to show that the VA healthcare caused you a disability through carelessness, negligence, lack of proper skill, error in judgment. You're essentially making a medical malpractice claim against the VA.
So this is distinct from the other four ways of establishing service connection because it's not related to your time in the service. This is post-service experiences.
Exactly. Section 1151 claims are a way to service connect disabilities that were caused by medical malpractice by VA healthcare providers. And so, example, let's say you have diabetes and you have an amputation and VA amputates the wrong leg. That's medical malpractice, and you can get your incorrectly amputated leg service connected and then rated, and you can receive disability compensation for that. Another thing to note is if you're the victim of medical malpractice by the VA, in addition to making a Section 1151 claim, which is going to get you service connection for that disability, you can also make what's called an FTCA claim. FTCA stands for Federal Tort Claims Act, and that's like a true personal injury lawsuit against the VA where you can claim pain and suffering. and receive just a lump sum monetary award.
Okay. So if you experience a disability as a result of this, there's the two separate ways you can go after compensation.
Yeah. And there's some offset rules. If you win both an FTCA and 1151, they may withhold money because they're going to say, well, you were paid for this under this claim. But generally, you want to make both. In addition, keep in mind for the FTCA claim, there's a 2-year statute of limitations from when you learn about the injury. If you don't make the claim within that 2 years, you can never bring it. 1151 claims, you can make it anytime.
Okay, so those are the 5 ways: direct, VA presumptions, secondary, aggravation, and 1151 claims. Before we wrap up this video, I did want to address something that people ask about all the time. It's when veterans say that they want to make a claim, but their records have been completely lost. You know, whether or not VA's made attempts to get them, that varies, obviously, veteran to veteran. But these are situations where VA can't get them and veterans can't get them. Do you have any suggestion or pointers for folks on how they can go about trying to make claims with absolutely no service records?
It's tough. I mean, a couple things. Every time you make a claim, VA tries to get service records. And I've had cases where 20 years ago, VA couldn't get them. And then the vet makes a new claim and VA makes a new request, and all of a sudden they're able to get them. If that's ever happened to you, there is a regulation that says you can get an effective date back to an initial claim when they didn't have your service records. You know, other than that, it is difficult. You can make your own requests. If you absolutely can't get them, you want to start doing things like lay statements from yourself and from friends and family and people you served with that can testify to like an in-service injury that you might have had. But it is a difficult situation.
But still potentially winnable.
Potentially. You should always try. Make a claim. The worst thing they can do is say no.
All right. That's all we've got for today's video. Thanks for joining us.
Make sure to like and subscribe. We appreciate your support.
Bye-bye.